Parliament enacted Constitutional Officers Remuneration Act, whose objective was to fix salaries and allowances of persons holding certain constitutional offices. Section 2 of the Act states that the salaries to be paid to the holders of those offices specified in the first column of the schedule to the Act, being the offices mentioned in Section 104 of the Constitution, were with effect from the 1st of July 2008 to be at the annual salary scales specified in relation to those offices in the second column of that schedule. There was a proviso to the section that where a salary scale is specified, the holder of the office was to be paid such salary within the scale as the President would determine, having regard to seniority and difference in skills, workloads, and accountabilities attached to the office. The holders of the offices specified in the first column of the schedule, including all judges, were to be paid such allowances as would be determined from time to time by the President. Section 4 stated that nothing contained in the Act was to preclude the payment to the holder of the offices specified in the first column of the schedule any allowance not determined in accordance with the Act, which he was eligible to receive other than or by virtue of the Act. Section 104(3) of the repealed Constitution thus ring-fenced judges' salaries and allowances so that their salaries and allowances could not be altered to the disadvantage of the judges while in office. During the repealed constitutional regime, the government introduced an allowance called duty-free car grant to certain cadre of constitutional office holders, including judges. They were allowed to buy or import vehicles duty-free for private use. That means the benefit existed prior to the effective date. The judges were among the officers who enjoyed this benefit up to the effective date. There is no doubt, and indeed there is consensus among all parties herein, that judges enjoyed this benefit up to the effective date. The point of divergence is whether the benefit transitioned to the present Constitution. In our considered view, the benefit transitioned to the new Constitution. This is borne by the fact that the Constitution abhors a vacuum. This finding is buttressed by Section 6 and 7 of the 6th Schedule. Section 6 provides, except to the extent that this Constitution expressly provides the contrary, all rights and obligations, however arising, of the government or the Republic and subsisting immediately before the effective date shall continue as rights and obligations of the national government or the Republic under this Constitution. Section 7.1 provides that all law in force immediately before the effective date continues in force and shall be construed with the necessary alterations, adaptations, qualifications, and exceptions necessary to bring it into conformity with this Constitution. The SRC Act came into force on the 29th of July 2011, and the first commissioners of the SRC were appointed on 10th January 2012. On 7th July 2011, before the SRC Act came into force, Ambassador Francis K. Mudaura, Permanent Secretary, Secretary to the Cabinet, and Head of Public Service, had issued a circular reference provided addressed to the Attorney General, Permanent Secretaries, Accounting Officers, Registrar of the High Court, and the Secretary of the Public Commission. The circular and a reference taxable allowance for purchase of motor vehicle stated, and we have set out in detail what that circular provided. We find and hold that the head of public service, aware of Section 6 and 7 of the 6th Schedule to the Constitution, as well as Articles 160 Subarticle 4 and 210 Subarticle 3 of the Constitution, and in order to obviate a constitutional vacuum, correctly issued the circular referenced above, thereby legally transitioning the benefit from a duty-free car grant under the repealed Constitution to a taxable car allowance accessible to officers mentioned in the circular, including judges, to conform with the 210 Constitution. Our finding is buttressed by the decision of the Supreme Court in in Communication Commission of Kenya and 5 others versus Royal Media Services and 5 others. In that case, the argument was that the promulgation of the Constitution on the 27th of August 2010 immediately rendered the Communication Commission of Kenya and all its actions thereafter unconstitutional. The Supreme Court rejected that argument, holding the transitional chapter and clauses in the Constitution are meant not only to ensure harmonious flow from the old to the new order, but also to preserve the Constitution itself, by ensuring that the rule of law does not collapse owing to disruptions arising from a vacuum in the juridical order. Unless it is demonstrated that the legislation establishing CCK was incapable of being construed with the necessary alterations and exceptions so as to bring it into conformity with the Constitution, pending the 3-year legislative intervention, it would be improper in law and in principle to declare CCK unconstitutional. In the same vein, the argument by the AG and the SRC that the benefit ceased to exist on the effective date and did not transit into the new Constitution is devoid of merit, given that the benefit to judges was ring-fenced by Section 104(3) of the retired Constitution and could not be taken away to the disadvantage of judges, contrary to Article 160, Subarticle 4 of the current Constitution. In the circumstances, we have no difficulty in finding, which we hereby do, that the taxable car allowance is a benefit to judges. We must also state that the allowance is a benefit attaching to the office of judge to be enjoyed by the holder of that office on appointment and not to an individual judge, as argued by the AG. This is because Article 160, Subarticle 2 protects the office of judge of superior courts so that the offices cannot be abolished while there is a substantive holder thereof. The benefit is enjoyed by virtue of holding the office, and therefore the benefit is to the office. This view finds support in the persuasive decision of the Supreme Court of Uganda in Attorney General of the Republic of Uganda versus Masalu Musene Wilson and others, where the court observed that when a law refers a justice of the High Court, it can only mean that any person holding that office is affected. The law thus applies to judges as a class, irrespective of whether they were in office when the law was enacted. What the government did was to extend a special privilege to judges by introducing a new term of service. The new term of service was in effect at the coming into force of the 1995 Constitution. Having determined that the allowance is a benefit to the office of judge, the next issue is whether termination of the allowance contravened Article 160, Subarticle 4 of the Constitution. I hand over to my brother.
The petitioner argues that termination of the benefit violated Article 160, Subarticle 4 and amount to interference with the independence of the judiciary. This position is supported by KWJA and the JSC. The Attorney General and the SRC take the opposite position, arguing that the promulgation of the 2010 Constitution brought in a different constitutional architecture and everybody is bound by this architectural design. The benefit was thus abolished by constitutional operation. SRC asserts that under the 2010 Constitution, it has exclusive mandate to set and regularly review remuneration and benefit for all state officers. Accordingly, action by the head of public service to confer the benefit was an a usurpation of its mandate. We have already held that the taxable car allowance is a benefit to judges, and a question regarding its determination must therefore be considered against Article 160 generally and Article 160 Subarticle 4 in particular. The scheme of Article 160 is to protect the independence of the judiciary. Judicial independence means shielding the judiciary and the judges from external interference by the political branches, executive and legislature included, and any other non-judicial actor in the discharge of its mandate to adjudicate on disputes presented before it. Judicial independence is critical for maintaining judges' impartiality in determining disputes before them, thus promoting the rule of law, democracy, and constitutionalism. For judicial independence to thrive, institutional and individual judges' independence must be secured from both internal and external actors. For this reason, institutional, legal, and operational arrangements are put in place designed to safeguard this independence. As Justice Aaron Barak stated at page 80 of his book, A Judge in a Democracy, quoted by Chief Justice Lama of the Supreme Court of Canada, he stated, "Judicial independence is essential for fair and just dispute resolution in individual cases. It is also the lifeblood of constitutionalism in democratic societies. Without judicial independence, there is no preservation of democracy and its values. Institutional independence is designed to build a protective wall around the judicial branch and to prevent the legislative and executive branches from influencing the way judges realize their roles as protectors of the Constitution and its values. The judicial branch must therefore be run on the organizational level in an independent manner. It should not be part of the executive branch and not be subject to administrative decisions of the executive branch." In Zambia, the Constitutional Court of Zambia stated in Sangwa versus the Attorney General that we are alive to the fact that the concept of judicial independence is broad and has two main facets, namely independence of the individual judges, which includes issues of appointment, security of tenure, removal procedure, and remuneration, among others, and the independence of the judiciary as a state organ. It is thus not in doubt that both aspects of individual and institutional independence are cardinal to ensure judicial independence. In Attorney General of the Republic of Uganda, we have already cited above, the Supreme Court of Uganda had the following to say on that aspect. We agree that Article 128, Sub-Article 7 is meant to be a pillar for the independence of the judiciary. The need for the judicial officers to be well remunerated, well compensated, to be able to uphold their judicial independence cannot be overstated. We agree with Mpagi Bagine J.A. when she states in her judgment, and they quote, "The underlying principle in the entire Article 128 is the issue of judicial independence and security of tenure, the latter being among the traditional safeguards of the former. This means, among other things, that the term of office, emoluments, and other conditions of service of judicial officers generally shall not be varied or altered to their detriment or disadvantage. This is an elementary safeguard to be found in most developed legal systems, where it took many historic struggle to establish a firm footing as the most fundamental of all safeguards to judicial officers' security of tenure. When this safeguard is destroyed by whittling away the provisions of Article 128 sub-Article 7, and judicial officers are put to the sufferance of the executive or the whims of the legislature, the independence of the judiciary is the first victim. The rationale under Article 128 sub-Article 7 is that there should be adequate salaries and pensions for judicial officers commensurate with their status, dignity, and responsibility of their office. Article 160 of the Constitution is designed to protect both institutional and individual judges' independence. In that respect, the article provides, which we have provided here, we don't want to go through them. Article 160 thus protects both institutional independence of the judiciary and the independence of office of judge, a key feature in maintaining the rule of law, a founding value of our nation, and a constitutional imperative in a democratic state. Article 160 sub-Article 1 demands that the judiciary acts only in accordance with the Constitution and the law, and should not be under the control or direction of any person or authority. This is institutional protection from non-institutional actors such as the executive and legislative branches of government and other non-state actors. Article 160, Sub-Article 2 protects the office of judge so that the office cannot be abolished while the holder is in office, while Sub-Article 3 ensures that the remuneration and benefit payable to judges is a charge on the consolidated fund. This guarantees remuneration and benefit payable to judges while in office, so that judges' remuneration and benefits are available when due to enable them meet their financial obligations and avoid financial embarrassment. In the same vein, Sub-Article 4 protects remuneration and benefit payable to judges from arbitrary withdrawal or diminution to the disadvantage of the judge. The protection envisaged under Article 160 guarantees the independence of the judiciary and the office of judge in the discharge of their functions and duties. The question that we must answer is whether the action by SRC to withdraw, or better still, revoke the taxable car allowance is a violation of Article 160, Sub-Article 4. On July 12, 2021, the SRC wrote to Dr. Joseph Kinyua, Head of Public Service and Executive Office of the President, a letter reference SRTS. We have given the reference number, captioned taxable car allowance for purchase of motor vehicles. The letter referred to the circulars dated 7th of July 2021, 2nd June 2015, and 4th June 2018. After drawing his attention to its mandate under Article 230 of the Constitution and Article 230 Sub-Article 4, SRC stated that whereas prior to promulgation of the Constitution of Kenya, by dint of the repealed Constitution and relevant statute, constitutional office holders were paid remuneration and benefits determined by the executive and other officials. This changed with the new Constitution, which gave it at SRC that mandate. The SRC further stated that it had come to its attention that by a circular dated 7th July 2021, the Head of Public Service awarded taxable car allowance for purchase of motor vehicles to several state officers, including judges. These were subsequently reviewed on 2nd of June 2015 and 4th June 2018. The SRC then stated, we quote, "The purpose of this letter, therefore, is to request your esteemed office to revoke the circulars in question, to wit, the circular dated 7th of July 2011, the circular dated 2nd June 2015, the circular dated 4th July 2018. Kindly note that the applicable remuneration and benefit for state officers is as set by SRC." End of quote. On 16th of January 2023, a letter captioned "Request for taxable allowance to purchase motor vehicle." The Principal Secretary, Minister of Public Service, Gender and Affirmative Action, State Department for Public Service, Mr. Amos Engathecha, wrote to the CRJ informing her of the SRC's decision as follows, we quote, "The Salaries and Remuneration Commission has terminated this benefit for July last year. We have tried to engage SRC to reverse this decision, but all in vain. This explains the reason we have taken long to respond to this. Meanwhile, the benefit is not available, but we are still engaged in discussions. Kindly advise the applicants accordingly." SRC did not provide the court the letter that was attached to that communication. On 7th of February 2023, the CRJ wrote to SRC under subject taxable car allowance for purchase of motor vehicles, stating, we quote, we kindly seek confirmation that the referenced circular dated 12th of July 2021 does not apply to judges. It is not clear to us again whether SRC responded to this letter. The petitioner argues that the letter dated 12th July 2021 purporting to terminate the benefit is in violation of Article 160 sub-Article 4 of the Constitution and an affront to the independence of the judiciary. This position is supported by KJWA and the JSC. The AG and SRC hold a contrary view. The SRC maintains that under Article 230 sub-Article 4 of the Constitution, it is the body that has exclusive mandate to set and review the benefit, and it acted within its mandate in terminating the benefit. We have considered the trail of communication between the SRC, Head of Public Service, and JSC over the issue. It is not clear to us whether the Head of Public Service acceded to the SRC's request to revoke the circulars. This emerges clearly from the communication dated 16th of January 2023 from the Principal Secretary, Minister of Public Service, Gender and Affirmative Action, State Department of Public Service, Mr. Amos N. Gatecha, being his response to communication from the CRJ, indicating that whereas the benefit was not available, they were, quote, still engaged in discussion with the SRC over the issue, end of quote. Given the inconclusive nature of the communication, the CRJ wrote to the SRC on the 7th of February 2023 seeking clarification. It's again not clear to us whether the SRC responded to that letter. Even with no conclusive decision on the matter, it would, however, appear that it was taken that the benefit had been terminated. We have carefully considered the parties' argument on this issue. We have already determined on issue 1 that the allowance was a benefit to the office of judge. We must therefore point out that the constitutional provisions must be read in harmony, and in this respect, Article 230 sub-Article 4, which mandated SRC to set and regularly review remuneration and benefit, must be read alongside Article 160 sub-Article 4, which ring-fences benefit to the office of judge, to bring them into harmony. It is therefore a misapprehension on the part of SRC to read Article 230 sub-Article 4 in isolation of Article 160 sub-Article 4, where benefit is already available to the judges. The principle of constitutional harmonization was well articulated by the Supreme Court in the matter of National Human Rights Commission, where the Supreme Court stated that our Constitution should be holistically and contextually interpreted, reading and analyzing one provision alongside again and against the other, so as to maintain a rational explication of what the Constitution must be taken to mean in light of its history, of the issues in dispute, and of the prevailing circumstances. This means, therefore, that the SRC's mandate under Article 230 sub-Article 4 to set and regularly review the remuneration and benefits of judges must be rationalized and harmonized with Article 160 sub-Article 4, so that where benefit has already accrued and is thus ring-fenced by Article 160 sub-Article 4, that benefit is beyond the reach of the SRC. The benefit can only be reviewed, but not in a manner that is to the disadvantage of the judge. We say this cognizant of the fact that Article 160 sub-Article 4 prohibits in no uncertain terms the variation or alteration of an accrued benefit to the disadvantage of a judge. In this respect, the attempt by the SRC, whether as purported by its letter of 12 July 2021 or by any other letter to terminate the benefit, is constitutionally impermissible. We are fortified in our finding by the decision in Solonzuki that remuneration of judges is one of the tenets of the independence of the judiciary, and that is why the remuneration and the benefit payable to or in respect of a judge is constitutionally enforced and are not to be varied to the disadvantage of the judge, and the retirement of the benefits of the retired judge are not to be varied to his disadvantage. A similar view is taken in Jonathan Munene, that the Constitution is not silent on the ring fencing of the judges on their remuneration and benefit, which aims at ensuring that judges render their services and mandate independently and impartially, free from undue influence or wrong, albeit uncertainties of what the future may hold. We fully associate ourselves with this pronouncement. This is not the end of the matter. The letter dated 12th of July 2021 sought revocation of two other circulars dated 2nd of June 2015 and 4th June 2018. Having upheld the validity of the circular of 7th July 2021, transitioning the benefit from the retired Constitution to the 2010 Constitution, what then is the fate of the circulars issued in 2015 and 2018 reviewing the taxable car allowance upwards? It is appreciated that at the time the two circulars were issued, the SRC had been constituted. It is also not in dispute that by 2018 the SRC had held several engagements with the Judicial Service Commission over the remuneration and benefit of judges and judicial officers. That notwithstanding, the SRC states that the circulars reviewing the taxable car allowance were never brought to its attention. Yet, in the letter dated 12th July 2021, the SRC states that the existence of the three circulars had, quote, come to its attention, end of quote, and therefore it sought their revocation. Further still, in the affidavit sworn on 12th of October 2023, Anna R. Gitau, the CEO of the SRC, in response to the petition, deposes at paragraph 36 as follows: that upon being informed by the head of public service that SRC had terminated the taxable car allowance on 7th of February 2023, the Judicial Service Commission wrote to the SRC and indicated that the taxable car allowance concerning judges is subject to protection of Article 160 sub-Article 4 and Article 250 sub-Article 8 of the Constitution. The second interest party further claimed that the said allowance cannot be withdrawn, that is the JSC. This was the first time Judicial Service Commission brought bear the existence of a benefit that judges have been enjoying unconstitutionally and illegally, end of quote. The disposition in the affidavit clearly contradicts SRC's position in the letter dated 12th July 2021, where it states that it was aware of the circulars of 2011, 2015, and 2018, and even mentioned the state officers who were accessing the taxable car allowance, including judges. In any event, a perusal of the two circulars dated 2nd of June 2015 and 4th of June 2018 shows that they were addressed to all principal secretaries and accounting officers, Registrar of the High Court, the Auditor General, and Secretary of Public Service Commission. In our view, the circulars were addressed to, among others, all accounting officers who must have included the accounting officer of the SRC. We are therefore not persuaded that the SRC only learned of the existence of the circulars in 2021 and that judges were accessing the taxable car allowance in 2023. The only conclusion we can make is that the SRC was aware of the two circulars upon their issuance. Consequently, we find that the SRC is not being candid as to when it became aware that judges were accessing the taxable car allowance. The SRC's inaction. There is no dispute that the mandate of the SRC under Article 234 is, among others, to set and regularly review the remuneration and benefit of all state officers. When the SRC was constituted in 2012, the benefit was already set and in existence, following the transition pursuant to circular dated 7th of July 2021, in conformity with Article 210, sub-Article 3, as read with Article 160, Sub-Article 4, and Sections 6 and 7 of the 6th Schedule to the Constitution. At that point, the SRC's duty was limited to reviewing that which was already in place. In spite of this, and being a recipient of the two circulars, the SRC did not protest or assert its mandate in relation to those reviews. It maintained a studious silence and allowed the benefit to accrue and crystallize under Article 160 Sub-Article 4 of the Constitution, thus has been accessed by judges as reviewed. Our finding is reinforced by the decision of the Supreme Court of Uganda again that we have quoted. The brief facts of that case are as follows. The respondents filed a petition before the Constitutional Court of Uganda challenging the imposition of income tax on magistrates' remuneration. The Constitutional Court allowed the petition, prompting the Attorney General of Uganda to appeal to the Supreme Court. The Supreme Court reversed with the decision of the Constitutional Court, holding that magistrates were not entitled to a tax exemption. Nevertheless, the Supreme Court, in interpreting Article 128 Sub-Article 7 of the Constitution of Uganda, the equivalent of Article 160 Sub-Article 4, stated, we quote, however, as we have already noted, the appellants and other judicial officers of the rank of registrar and magistrate have been enjoying the privilege of tax exemption for over 3 years. The appellant did not apply for stay of execution of the judgment of the Constitutional Court, and the government has, in its wisdom, not been taxing the emoluments of the said judicial officers. It would be unconscionable and contrary to the spirit of the provisions of Article 128 Sub-Article 7 of the Constitution to remove the tax exemption. End of quote. In this petition, the SRC's prolonged inaction allowed the benefit to accrue, thus became one of the terms and conditions of service for judges. Judges have been appointed since 2011 and have been enjoying this benefit since then. By parity of reasoning, the benefit acquired constitutional protection under Article 160 Sub-Article 4, and for that reason the benefit cannot be taken away, as this would amount to a variation of judges' terms and conditions of service to their disadvantage. We therefore find and hold that the SRC's prolonged inaction, coupled with the enjoyment of the benefit by judges for a long period, sanctioned the reviews contained in the two circulars dated June 2, 2015 and 4th June 2018, and the benefit acquired constitutional protection under Article 160 Sub-Article 4. In conclusion, having regard to what we have said above, we have arrived to the following conclusions. First, this court has jurisdiction to hear and determine the petition. This is because Article 160 Sub-Article 3D Roman 2 of the Constitution confers on the court jurisdiction to determine whether anything said to be done under the authority of the Constitution or any law is inconsistent with or in contravention of the Constitution. The petition challenges the constitutionality of the action taken by the Salaries and Employment Commission, which had nothing to do with the employer-employee relationship. Second, the taxable car allowance is a benefit to the office of judge. It was conferred under the retired Constitution as a duty-free car grant, which enabled judges to purchase vehicles for private use. The benefit transitioned to the 2010 Constitution by virtue of Section 6 and Section 6 and 7 of the 6th Schedule to the Constitution, as read with Article 210 Sub-Article 3 of the Constitution as a benefit under Article 160 Sub-Article 4. Third, the taxable car allowance benefit and subsequent reviews is ring-fenced and protected under Article 160 Sub-Article 4 of the Constitution and cannot thereby be taken away, altered, or varied to the disadvantage of judges. The position, in view of what we have concluded above, the appropriate orders that commend themselves to us and which we hereby make are as follows. 1. A declaration is hereby issued that the tax for car allowance for purchase of vehicles for private use by judges that existed prior to 12th of July 2021 constitute a benefit payable to and in respect of judges under Article 160 sub-Article 4 of the Constitution and cannot be varied or altered to the disadvantage of judges. 2. A declaration is hereby issued that the Salaries and Remuneration Commission's letter dated 12th July 2021 purporting to revoke the taxable car allowance contravenes Article 160 of the Constitution, is a threat to the independence of the judiciary, and is therefore unconstitutional, null, and void. 3. An order of certiorari is hereby issued quashing the Salaries and Remuneration Commission's letter dated 12th July 2021 to the extent that it purported to revoke the taxable car allowance for judges. 4. An order is hereby issued compelling the Principal Secretary, National Treasury, and Economic Planning to forthwith process, pay, and continue to pay the taxable car allowance to judges as and when they falls due. And finally, this being a public interest litigation, we make no order as to costs. Thank you. Yes.
I would wish first to join in seeking a stay and applying for a certified copy of that judgment. Specifically, Your Lordship, and my lady, will be seeking a stay on the order containing the Principal Secretary, Treasury, to release the monies relating to this particular subject matter for a period of 60 days to allow us to lodge an appeal against the instant judgment. Thank you, Your Lordship.
My lady, I think we will oppose the application for stay, but 60 days is on the higher side. I think 60 days is too long. Period. Maybe 30 days.
Any other part? Are you done?
I'm done.
Any other part?
Yes, my Lord, my lady, on behalf of the Secretary of Justice, Mrs. Maina, we are opposed to the granting of stay. My Lord, my lady, you cannot issue a stay in a decision which has already been declared unconstitutional. Let a formal application be filed for parties to respond.
My lords and my lady, on behalf of the first, but I will brief for Mr. Simiu for the first interested party.
Did you get your name?
Yes, I believe my senior introduced me.
Spell it, please.
MBATAI. Mbatai, I do hold brief for Mr. Simiu for the first interested party.
Yes.
I wish to join issue with Mrs. Minor, what Mrs. Minor said. We are equally opposed to the application for stay. Should the respondents be interested in obtaining a stay from this court, let them file a formal application. That's all.
So we retire to consider your application.
Tutapeleka hii moja kwanza.
Sekarang